Hi, y'all, and welcome to tonight's live stream. Well, Trooper Michael Proctor has not even taken the stand in this Karen Reed retrial, but his presence is everywhere. He was mentioned 32 times in the opening statement by the defense. We are nearing the end of the Commonwealth's case, and it is abundantly clear that if the Commonwealth was hoping maybe they could just quietly move on, without having to actually deal with the wreckage that Trooper Proctor left behind, they were mistaken. Now, Proctor was terminated, dishonorably discharged from being a trooper because of his conduct with respect to the Karen Reed case. We are going to look specifically at what the findings were tonight. Now, the defense is trying to put Proctor right in the middle of the case, even though he hasn't testified yet. Trooper Yuri Buchanan, who was Trooper Proctor's former boss, took the stand and got grilled over sloppy evidence collection, missed taillight pieces that appeared over and over again, and unsealed solo cups that were used to carry biological material. Now, the defense painted a picture of just utter chaos, not just incompetence, but deliberate, biased investigation that was led by someone who never should have touched the case. Now, it's occurring to me, I need to go over here. I'm busy talking. I've been gone for a long time. Let's make sure y'all can hear me and that everything is going okay on that. Hopefully you don't see anybody complaining. So good. Okay. So let's keep going. So they are not just trying to poke holes in the Commonwealth's case. What the defense would like to do is to burn down the case using Proctor as the match. So we know Proctor made crude comments about Karen Reed at her expense and also trashed Karen Reed's lawyer. And the jury has heard about that in this case. We have also heard about the cozy relationship that he supposedly had with the Albert family. We're going to talk about what those statements are. And of course, that's the exact family in whose house, or right in front of whose house, John O'Keefe was found lying in the snow right where he died. Now, we also saw how Trooper Proctor just happened to repeatedly find physical evidence, like pieces of taillight, that other people had somehow missed. But the most important question is whether or not Trooper Proctor had a hand in breaking Karen Reed's taillight, had a hand in pulling the pieces out and scattering them around the scene. That is the most important allegation, because that is critical evidence tying the death of John O'Keefe to being hit by a car, because Trooper Proctor did have access to Karen Reed's SUV before a single taillight fragment was found at the scene. That's the Commonwealth's key physical evidence. And they have, through Trooper Proctor, handed the defense a reason to say it was planted. So what we're going to be talking about tonight is, how much is the specter of Trooper Proctor affecting the case? Is it destroying the state's case, the Commonwealth's case, or is the jury going to look right past it, look directly at the evidence, not worry about who collected it? Are they going to believe Trooper Proctor destroyed evidence or overlooked it or created it? So we're going to take a look at what the defense said in the opening statement, what they said they would prove or would show, what the facts would show about Trooper Proctor, and we are going to take that and relate it and compare it to what exactly the Commonwealth has proven so far in this case. So let's get into it. I want to shout out the first 5 in tonight's chat: Denny, Scorpio Moongal, KCAM4, Holly May, and Camilla Juliana. By the way, we are just 2,200 subscribers away from hitting 200,000, which is absolutely wild. If you have been watching but you haven't hit the subscriber button yet, please hit that subscribe button. Help us cross that milestone, and I would love to celebrate it with all of you. We are going to have a very special outro tonight done by our own Marlon, and happy birthday to Marlon. He just recently had a birthday, and this is our first live back since his birthday. So happy birthday, Marlon. So we are going to be asking, we are going to be talking about the question of Trooper Proctor and what effect he's had on the case. So let's go ahead and talk about what was said in opening statement. And I described sort of Trooper Proctor's what he's done in this case is sort of a series of gifts for the defense. Like, oh, here's another thing Trooper Proctor did for you. Things that help the defense because of what Proctor did. Now, if what he thought he was doing was harming Karen Read, then he's mistaken. It has backfired. Let's talk about the Proctor effect. Number one thing I want to talk about is flawed and incompetent investigation, maybe even corrupt, although frankly, the defense team is leaning into that a lot less in this trial than they did in the first trial against Karen Read. So I'll talk more about what I mean by that kind of as we go through the video. So what are some of the things I'm talking about? I'm talking about collecting blood in red Solo cups, using a leaf blower, not documenting where they found the taillight pieces, where in the yard they found it, taking a month to find all the taillight pieces. So that sort of incompetence hurts the case of the Commonwealth. They have taillight pieces that were found at the scene. They have taillight pieces that were in John O'Keefe's shirt. Those are powerful facts. In most cases, that would be extremely powerful. It would be something the jury would be finding almost overwhelming, but Trooper Proctor's actions have undermined the ability of the Commonwealth to use it in this case. Now, technically, he was not fired for incompetent collection of evidence. He was not fired for adding evidence, anything like that. But the fact that he was wrongfully discharged, we'll take a look at that in just a minute, all of that is going to matter in this particular case. Let's go ahead and take a look at Alan Jackson, a little excerpt from opening statements by Alan Jackson.
Learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Read end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any? Answer, nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. The story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted, and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. No.
Okay, let's stop there. So what he's talking about here is the incredible power that Proctor's misconduct and what he did is having on this case. It's not just a question of the evidence. It's a question of who collected the evidence, of who actually found the evidence, of who compiled and decided what was evidence and what wasn't. I want to take a look now at the actual document. This is the document that was used. It's taking me a minute. Let me remove that and then add this. Okay. This is the document, the Department of State Police personnel order, where Proctor was actually let go. He was terminated wrongfully. Did I say wrongfully discharged earlier? It was he was found to have engaged in wrongful conduct, and was dishonorably discharged. Hopefully that's what I said last time. But I want you to take a look at why, because frankly, they were fairly careful not to pin anything on him that would directly affect the case. And of course, we haven't heard anything about this particular finding, but we have heard that Trooper Proctor is no longer serving as a trooper. We've heard that he was dishonorably discharged. So I've highlighted in yellow the 4 reasons that they found he should be dishonorably discharged. And I'll read the first part. Trooper Proctor, on various dates, and they give them, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. And the dates start with when John O'Keefe was found in the snow, January 29, 2022. So all of these, they're saying on each of these, this is the period of time, and he failed to conform to work standards. And here are the 4 ways. First, this occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, sent derogatory, defamatory, disparaging, and or otherwise inappropriate text messages about a suspect in that investigation to other individuals. Now, technically, that is not something that has to do with the collection of evidence, right? These are the text messages that Trooper Proctor sent about Karen Read, and they were incredibly offensive. So offensive, YouTube demonetized my video on this a year ago, when all I did was play what he actually read into the court record as what his text messages were. It was really wildly inappropriate. Are those directly affecting the case? No, but they do show an attitude, and that's what the defense is leaning into. Okay, next. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, which makes it kind of funny, right? That Buchanan, his boss, is like, oh, I wouldn't call him the lead investigator. Really? Because the state did, the Commonwealth did, that occurred while assigned as lead investigator, provided sensitive and or confidential information about a homicide victim, potential witnesses, and or potential investigative steps in the investigation to non-law enforcement personnel. And what they almost assuredly are talking about is the series of text messages that Trooper Proctor sent about Karen Read, about the investigation, to a group of friends from high school, from back in his high school days. Clearly, they had no business knowing any of that, and he was telling them what he was finding. He was telling them information. Again, not directly related to the evidence itself or the collection of evidence or the validity of the evidence, but it's pretty important in terms, again, of what he was thinking and what his attitude was. Next, third one, this occurred when Trooper Proctor, while assigned as the lead investigator, again, in a homicide investigation, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with the homicide suspect and or brought otherwise himself and the Massachusetts State Police into disrepute. Now, that's as close as it gets to them saying that he did something wrong in the investigation. They don't say he technically did anything wrong, but it certainly made us look bad. That's basically what they're saying, that he had unprofessional and inappropriate conduct, and it created an image that he was biased. Now, it doesn't go so far as to say he was biased, but that it made it look like he was. And it brought him into disrepute. It brought the Massachusetts State Police into disrepute, just meaning looking bad, making us look bad. And lastly, the fourth way, this occurred when Trooper Proctor consumed alcoholic beverages while eating dinner on duty and then proceeded to operate his department-issued cruiser. That came out during the examination of a witness in the last trial, that he actually had been drinking on the job. They went out to dinner, they've been drinking, and then he drove his cruiser. And that came out during the testimony. So those are 4 different things that they found were relevant to what Trooper Proctor had done wrong. Now, as I said, none of those are he failed to collect evidence that he should have collected. None of those are he made up pieces of glass and put them on the bumper. Nothing that directly goes to help Karen Read with her case, but all of it is being used by the defense to good effect. So let's head back into how the defense is using it, whether it's working, and what the Commonwealth is doing to try to combat it. So as you heard in the description of what was going on. Now, there was Yuri Buchanan, the boss of Trooper Proctor, actually testified. Now, Proctor, like I said, has not testified. We don't know whether he will be brought or not. Karen Read was talking to the press one day afterwards, after trial one day, and she was asked, is he going to testify? And she said, don't know. We'll decide when the time comes. So the first problem was with Yuri Buchanan was he wouldn't admit anything about Trooper Proctor. He wouldn't admit that Trooper Proctor's conduct had been bad. He wouldn't admit that it had been inappropriate. He wouldn't admit even that Proctor was the lead investigator, something you see over and over in that report. So, and we knew that, and they read into the transcript, the text messages where Trooper Proctor actually said to Buchanan, his boss, as well as to other people, that he was looking through Karen Read's phone for evidence in a potential homicide investigation. And he said, no nudes so far, as if that had anything to do with it. And the newspaper article, he was also shown a newspaper article that mentioned Karen Read's lawyer, whose name is Yannetti, not the one doing the examination we're going to be watching today. And his response was, I hate that man. I truly hate that man. Again, really inappropriate and off. So the boss, Buchanan, and other troopers were on these group text messages, and no one, absolutely no one, said, wow, this is wildly inappropriate. Like, what are you talking about? The question was, well, couldn't you have said something like, wow, we're going to talk about that in the morning. Please come see me. Nothing. No one objected. Buchanan's response was a thumbs up or a heart. That it all seemed to be pretty okay. So let's listen to a little bit more.
Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood.
These are all things that he didn't do with his investigation, which is a highly legitimate way for a defendant to argue, and in fact, a constitutionally protected way for a defendant to argue that the investigation did not thoroughly consider other options, other alternatives, didn't thoroughly gather the evidence that might have been used to protect this defendant from the prosecution. So, but it really went further than that, because Buchanan, the boss, gave Proctor a rating of exceptional and insisted at trial that his investigation, yes, had been ethical, and didn't do some of the things that probably would have helped, like just say, yeah, he really did some bad things there. So glad he's not with us anymore. Nothing like that. He did not distance himself from Proctor in that regard. So the second way I think that Proctor is really affecting this case is by casting doubt on the evidence that the Commonwealth has. Because of Trooper Proctor's problems, his troubles, the things he brought on himself, frankly, his credibility is below zero. It is negative. It's not a positive. The last time the defense really pushed hard on trying to prove that third parties had actually committed a homicide against John O'Keefe and left his body there, and that this was all a framing incident. They are taking a much more cautious approach this time, and they've been given that freedom by the things that Trooper Proctor has done. Now, technically, of course, the defense doesn't have to prove that a third party committed this crime. They only have to show that there is reason to doubt. There is a reasonable doubt about what the defense is claiming, about what the prosecution is claiming, because the Commonwealth has the burden of proving Karen Read committed the crime she's charged with beyond a reasonable doubt. That's up to the Commonwealth to do. But it is obviously better and easier if the defense can close the loop. But what's happening in this trial is what Trooper Proctor has done is giving the defense the ability to not push as hard as that, to say, hey, look, these things could have happened, but not to try to actually prove that Brian Albert or Brian Higgins or anyone else actually committed these murders. They're able to sit back and take a more measured approach. And that is making a difference in the case. They are treating Trooper Proctor as, and called him this in opening, a malignancy, a cancer. In fact, let's go ahead and hear that.
You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation. It's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it.
I'm going to try to get back. I want you to see that picture right there. Let me see if I can capture it. It's so quick. I tried really hard to figure out how I could expand it, but I couldn't figure it.
Has his fingerprints on it.
There. Oh, good. I got it right there. Okay. So what the defense is managing to do this time around is to use Proctor's involvement to actually cast doubt on key pieces of evidence. For just about every witness, they've gone through the process of asking about anything and everything that Trooper Proctor had to do with their work. Did Trooper Proctor collect the evidence that was given to you? Did Trooper Proctor hand the evidence to you? Did Trooper Proctor sign the document that shows the chain of custody for this piece of evidence? And it has become very difficult for the Commonwealth to deal with because more and more of Trooper Proctor has spread throughout the case. And at this point, he hasn't testified, but he's probably the most important non-witness ever to take part in a case or not take part in a case. So Proctor, for example, kept finding pieces of taillight. And one of the things they did very effectively with Yuri Buchanan was talk about what these pieces of taillight looked like, because they were found over and over again, sometimes by Proctor without anyone else present, one time by the chief, the local Canton police chief, who then handed them to Trooper Proctor or brought Trooper Proctor out. Nobody documented these. Only Trooper Proctor was able to find these, to collect them. No other people had searched the scene and they hadn't found these. And they weren't small pieces. You can see from the ruler that's shown here, these are the kind of pieces that they were talking about. They went through details like that with Buchanan and said, okay, here's one. It's 7.5 to 8 inches long. There's another that's 3.5 inches long. They went through all of that. So how did Buchanan manage to miss that in his search so that then only Trooper Proctor found it later? And he admitted there hadn't been very much snow on the ground when he did his search. Here's something from Buchanan's testimony.
There was very little, but there was still snow on the ground.
You indicated that you obviously looked around the area. You talked about the general area. I think you used the word general vicinity, right? When
Yes.
you collected your items.
Yes.
You didn't see this, and you didn't see the one before it either, did you?
If I saw any of these items, they would have been collected.
So Proctor, as I said, is being used to discredit a lot of evidence, the taillight pieces being the most important, I think. But Proctor also is the person who accessed the footage of John O'Keefe's ring camera. Remember, it's missing two particular incidents where Karen Reed went to John's house, One Meadows, or left John's house, One Meadows, February 3rd, the 8th, the 11th, and the 18th. Let me scratch that. That goes from the above. Skip that, not February 3rd, 8th, 11th, and 18th. I would say the Commonwealth has suggested that Karen Reed deleted this stuff herself. They've suggested that it was Karen who did this. She was there with her dad. She didn't want the police to know about her cracked taillight, maybe. They've insinuated that. And so she deleted it. But here's the problem. Trooper Proctor accessed the footage. That gives somebody else who could have deleted it. That gives the jury a reason to think maybe it wasn't Karen Reed who did it. So it's undermining the evidence and the argument that the Commonwealth would have made. They've also used it pretty effectively, I think, to undermine the chain of custody. Well, if it's Trooper Proctor who brought this to you, who knows what happened between the time it was collected and the time it got to you. That way, the defense has not had to target every single member of law enforcement as if they were involved in the corruption and they were involved in figuring out what exactly Karen Reed could be charged with and framed with. Instead, they're able to say, well, you probably did your job just fine, but this middle box here where Trooper Proctor was in charge, who knows what happened during that time frame. So that's all been pretty effective. And as I said, I think it's put a lot less pressure on them, on the defense, to prove this third-party culprit that they focused on so much last time. It's not that it's not in the case. Very much it is. But it's just less important, I think, than it was last time. It's less of a focus by the defense. So let's listen a little bit more. This is here.
Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. You'll learn.
So you hear kind of the difference in that? He's focused, yes, on the idea that Brian Albert might be guilty, might be hiding something, might have done something, but it's not really necessary to prove Brian Albert actually did that, because he kind of pivots at the end there into talking about how the investigation wasn't done. It could have been Brian Albert and nobody even bothered to look because Trooper Proctor was in charge. That's the argument they've been making. I actually think that's way more effective than in the first trial. And the reason I think that is it's really hard to prove a conspiracy, because especially a big one like this, where a lot of people have to be involved. And the defense has been kind of freed from having to do that. And it is difficult to convince the jury that law enforcement, especially multiple members of law enforcement, were involved in a conspiracy to frame somebody. It's not impossible, but it's hard. And if they don't have to do that, if they can just say, look, here are all the people who were, who might have been suspects, and Proctor never bothered to look. I think that's a much easier case for the defense. And I think it's a more effective case for the defense. So I think this has actually been pretty important. I think it's important that the defense isn't kind of leaning into that third party culprit issue this time. They're insinuating it, but they're just kind of letting it lie and pointing out, besides, nobody bothered to look. And that's been pretty effective. Of course, the relationship between Proctor and the Albert family has been important both in the first trial and this one.
That Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any, end quote. And that was for one reason, and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went.
So, of course, another huge third-party culprit issue fought in the first trial related to Brian Higgins. He is the man with whom Karen Reed was having a relationship of some sort, and they had written text messages back and forth. Now, we've heard those in this trial. We have heard about that, but there is less of a focus on Higgins, and he has not testified.
The two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence.
So over and over, pulling back to Proctor, there's a potential third-party culprit. Let's go back to Proctor. And that is really giving the defense a huge benefit compared to what they had to deal with in the first trial. It's really making, I believe, a significant impact in the case. So Proctor also has been accused by the defense of overlooking evidence. Huge example would be the snowplow driver. Now, we have not yet heard from the snowplow driver. I would expect to hear from him in the defense case, which starts probably this week, maybe as soon as Wednesday. But we have heard about the snowplow driver from Proctor's boss, Buchanan.
There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that the Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time.
So, and if you remember from the first trial, we heard some really important evidence that I don't believe has come into this trial yet about Brian Albert and Brian Higgins both destroying their phones, which is weird enough in and of itself, and the extent to which Brian Higgins went to conceal what he had in terms of breaking the SIM card, throwing it out in a dumpster on a military base, and not turning it over. But of course, we know that he first printed out text messages he had sent to Karen Reed and turned those over to law enforcement after he had destroyed the phone. But again, there is talk about that in opening, even though I don't believe the facts have come in yet at trial. But it's cast in a theme of Trooper Proctor overlooking the evidence.
You'll also learn after this incident, and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn, Brian Albert got rid of. Shortly after this incident, Brian Albert got rid of his house, the whole thing, just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else.
Let me give you one last example before we go to the next point. Jen McCabe. Trooper Proctor is again cast as overlooking important evidence related to Jen McCabe and to her knowledge about whether or not John O'Keefe was lying in the snow, the Haslon famous search that she did.
You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted.
So we're about to go into our fourth point. I do want to say a special thank you, SheFly9. I'm very glad to be back too. Thank you for being back for my first live after being away. Coles has been a member for 10 months. Delighted to have you. And Gina has a great point. Subscribing is free, and you can really help us. We are only 2,200 away from hitting 200,000 subscribers. So please help us get over that mark. We would love to have you along as a subscriber. Marlon is saying that people have given him happy birthday wishes. So I will as well. Happy birthday, Marlon. Marlon is one of our 2 mods along with Mama Pinks. So incredibly grateful to have them. And Carol Jackson is a brand new member. Glad to have you, Carol. And Avalon has been a member for 8 months, which is awesome. Thank you so much. Megan, I really appreciate the super chat. And I think a lot of us would like to know what goes on behind the scenes. I can tell you this, they didn't take any time off this weekend. I can pretty much guarantee you they all worked most of the weekend, maybe all of the weekend. There's just never time off really during trial. I'm sure they are constantly updating, thinking what they're going to do next, preparing witnesses, preparing questions for witnesses. All of that's happening. So, okay, let's move into my last point. Trooper Proctor has been used not just to cast doubt on the evidence that has been found, but also to suggest that he created evidence, that he made up evidence that isn't even something that should have existed, that he went out of his way to break the taillight, take pieces, put them at the scene in order to frame Karen Reed, that this is a deep conspiracy, that Trooper Proctor was part and parcel of it, that he used his authority as lead investigator to try to set her up, to try to place evidence right at the scene that would make her look guilty. So let's listen to a clip about that.
As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor, and he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero, nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. You'll learn that.
All right. So I'm going to try to remove that all the way. Okay. So I want to talk now a little bit about what we've just seen. The point I wanted to make was I wanted to take a look at just how much what Trooper Proctor did has harmed and whether or not it's made a difference for what's happened in this particular retrial. Is it hurting the Commonwealth? And I don't think there's any question about it. Trooper Proctor's conduct, Trooper Proctor's dishonorable discharge has had a tremendous impact. You can see the way it's affecting the burden that the defense will have to bear. And I don't mean a technical burden in the sense that the law requires it, but just in the sense of persuading the jury. They've been freed up in a lot of respects not to have to prove as much as they wanted to last time in order to persuade the jury. And there are also issues around his conduct with respect to the taillight. And the fact, even though that the charges that were found truthful in the dishonorable discharge finding, those didn't relate to Trooper Proctor breaking the taillight. They didn't relate to Trooper Proctor creating evidence or failing to preserve evidence. None of that was as we went through, you can see, none of that was actually in what those charges said. And yet, I think this is making an important difference because the jury does know that it is true that what he was charged with related to this case, even though it wasn't those facts. So it's clearly making a significant impact. So then the question is, and that I posed, has Proctor already doomed the Commonwealth? Is what's happened so far enough to convince the jury in and of itself? I think the answer to that is no. I don't think the case is over. I don't think the case is closed. I think this is important, but I don't think it's enough yet because the jury still has actual physical evidence and they have to make the decision about those pieces of taillight. There have been witnesses who have said some of them were found on the ground around the body, not just in the snow, on top of the snow, but on the ground. And I'm talking about in the early finding of the pieces. Then there were pieces and a hair, for example, that was on the taillight. It is entirely possible that the jury will conclude that those physical findings are strong enough to overcome that Trooper Proctor is a specter in the case. Trooper Proctor is a constant problem, a thorn in the side of the Commonwealth because of the fact that his conduct undermines their evidence. And the defense is very effectively using it to show that. It doesn't end the case, but it's important and it's making a significant difference. It was true last case because a lot of this had already been proven, but I think it's even more difficult for the Commonwealth to run from it this time, both because he has been dishonorably discharged and just because all of the witnesses already know the facts around Trooper Proctor now. So they really can't run and they really can't hide from it. So let's take a few questions. Let's talk a little bit more about this. If you have a question, if you would put your question marks at the beginning, I will, that makes it a lot easier for me to find. So let me come over here and there's a question over here from Tina T over in the super chat. And she's asking, has it ever happened that the prosecution is losing their case so badly that they stop the trial and immediately drop the charges? And Tina T is all in belief that this is one of those cases. As far as, has it happened? Yes, absolutely. It has happened that you get into the middle of the trial and it just, everybody realizes, whoops, wrong case. But boy, is that rare. It would be very unusual because normally the witnesses have been vetted, the evidence has been gathered. And so the prosecution, even by bringing the case, is making an assertion that they believe it's a valid case, that there's reasonable good faith basis for bringing it. So it's very unusual, but is it possible? Sure. I don't think that there's any possibility in this case that the Commonwealth will do that. And I don't think there's any possibility that, I'm sure at the end of the Commonwealth's case that the defense will make a motion. The judge is really unlikely to grant that. Melanie, thank you so much. I appreciate that. Thank you. And Baba D has a question. Is the charge murder? Let me go ahead and put that up. At the very most, this might be unintentional homicide. If the jury thinks the same, can there be guilt of murder? There are actually 3 different charges here. And it is very possible that the jury can disregard the second-degree murder charge and still find Karen Read guilty on one of the other 2. In fact, the first jury was leaning toward that. As we understand from what they said when they came out afterwards, they were pretty solid on 2 different charges that Karen Read was going to be found not guilty of those. But there was a 3rd charge related to manslaughter and a couple of different forms of that where they hadn't made up their minds yet. And so it is very possible that the jury will say, okay, we really don't believe second-degree murder, but, this is clearly manslaughter. That is possible. That is something that can happen in the case. Okay, let me head back over here and see what questions I can find. I'm going to have to move back up a little bit to find people who put it in early. Okay. I don't know if I went far enough, but I'm going to start with Gloria S. Will we ever know why the feds were investigating? And is the investigation really closed? That's what we've heard. And we've heard that from multiple sources, including from all the parties in the case, from the judge. The understanding is it's over. As far as their findings, apparently no one is going to be charged. And the prosecution, the Commonwealth, came rushing into court and said, we just want you to know, Judge, it's all over. And we've been told that. As far as I know, that's the case. I don't believe there's any reason to think that there's some other investigation going on or some further investigation that isn't known. As of this time, I think everybody believes it's over and that no one is going to be federally charged. There were consequences for Trooper Proctor, but apparently the decision made by the United States Attorney was it did not rise to the level of a federal crime. So that's what I would assume from that. I'm looking for question marks at the beginning so I can find, they're a little easier to spot in the chat. How come this case hasn't been thrown out? Al, similar question to Tina's a minute ago. I don't think it's even close to that. I think there is definitely evidence supporting the prosecution side, and that's really all that the standard requires for it to go forward to the jury. Now, what the jury does is a completely different matter, but is there enough to move past the motion? I think there clearly would be. It's not a super high bar at this stage. Can Proctor be brought up on charges? S. Cipher asks. Certainly it would be possible, but it appears that's not going to happen. It appears that what happened for him was this discharge, and that's it. That will be the consequence for him, and that there won't be other ones. Do we know that for sure? No, but that's what I think. Why doesn't John O'Keefe's phone register an impact? Jay Allison asked. So the phone testimony, they went through all of that on the last couple of days of trial. And frankly, I found it very difficult to follow. I'm putting it all together in a timeline right now because I'm trying to follow it so that I can explain it to you. As I felt like it was confusing. We had a shift of the time that was done by one Commonwealth witness. He explained why he did that. We're going to be hearing from a defense witness who says that shifting the time like that was inappropriate. The Commonwealth expert was trying to sync various clocks that were keeping time. There was John O'Keefe's phone, Karen Read's phone, and Karen Read's car, which had an infotainment system that recorded various things, a black box, and it all was pinpointed with times. So I think there was a lot of information, and I couldn't tell you for sure why any of that is the case. I will say this, the Commonwealth should have made it really clear to us, I think, by the end of that testimony with Shannon Burgess. I don't feel like they quite made it. I don't feel like it was fully explained to me. Now, we will see if the defense does any better in explaining it, how much better their witness is. The Commonwealth hasn't finished its case. We are going to be hearing most probably, at least tomorrow, we're going to have the accident reconstruction. And I'm really looking forward to that because I have tons of questions around that. And I hope it's a really good, solid explanation for us. Would you call Proctor, White 007 asked me, and if I were defense counsel, or would you let his absence bring doubt? It is a really hard question. There are some juicy facts that the defense would love to get in that aren't in yet. And if they call Trooper Proctor, I know they would be hoping to do that. But they also know that they would not have Trooper Proctor on cross-examination. They would have him on direct examination unless there was a ruling or a finding by the court that would change that. So that means the questioning would be a lot more difficult. Instead of being able to say, isn't it true that such and such, they'd have to say, what did you do next? And things like that. It's a lot harder to get really deep information from a hostile witness on direct examination. It would be really hard. So if they could get the witness declared hostile, maybe they could get the witness on cross-examination, but I think that's a far-fetched, a far cry from what the judge is likely to do. It would be far-fetched. So would I put Proctor on the stand? I probably would. To be honest, I don't really see a lot of downside. It isn't like Proctor has a ton of information that the Commonwealth hasn't already presented, but there are some things that he would be able to get in that others have not. I am a little concerned about whether the Commonwealth has successfully laid a foundation for some of the pieces of evidence when they're missing Trooper Proctor as the link between when it was found and when it was given to someone in one of the positions to evaluate it, one of the labs, and so forth. Dorothy W. is asking, is it true a juror from the first trial is assisting the defense? If true, do you see any influence he or she may have had on the defense? And Dorothy, that's a great question. Yes, there is a juror from the first trial who ended up being an alternate, just also happened to be an attorney and is now serving as an attorney. I don't know, paid or unpaid, but for Karen Read. Is it affecting the defense? I doubt it. I don't really think that there were a lot of questions around that. I imagine she's there mostly to assist with any kind of discussions about how the jury might perceive something, or maybe how her jury perceived it. But since it's a brand new jury, I don't think that would be something that would be regularly used. It would just be used on occasion when they needed some information from her. I believe she's not normally a litigator, so she doesn't normally go to courts or trials. And so this would be a bit different from what she would do on a day-to-day basis. Al Schmidt, has the defense not asked for a different judge? I cannot recall if they moved to recuse Judge Canoni. For sure, she didn't leave. If they asked her to, she did not. It's not uncommon that the defense will ask the judge to recuse him or herself. I will say this about asking a judge to recuse themselves. They never do that. They never do that. It's just, it never happens. And on several occasions, I would be working with a team and somebody would say, let's move to recuse the judge. And my answer was always, no, we absolutely should not do that. It's that old saying about, if you come for the king, you better kill the king. You better capture the king, because you will not get away from the consequences if you are not successful, and you just are never successful. The appellate court isn't going to do anything about the fact that the trial court is not going to recuse him or herself. So very, very unusual circumstance for you to do that, in my opinion. Andrea is asking why weren't there fingerprints found of Karen Read? And I think that they didn't really dust or look for fingerprints of Karen Read because she'd already been all over her boyfriend. I mean, for one thing, they were dating, but also she had gone over to him. She was lying on top of him in the snow. It was her car. So I don't know that there was anywhere they could really dust for fingerprints that would give them information. She was already there. She was expected to be there. So her fingerprints would be most likely to be there. That would not be unusual. Paul asking, can you please comment on the Commonwealth motion to exclude the FBI text, the Proctor text, as hearsay? I haven't read it yet. I'll have to read it, Paul. Thank you for telling me about it. I will take a look at that, and maybe I can have a comment on that then. Any guess how long the defense case will be? Nell asked. They said, and I believe this was just on Thursday, they said that they were expecting maybe a week and a half. I can't remember if that was at the beginning or more recently, but roughly a week and a half. So we could be winding this up, not end of this week, but end of next. That's actually a possibility. Anja asking me, can the medical examiner change her findings at any time, or will it always be undetermined? She talked about the fact that there is a 90-day window for her to collect additional information and make changes. That window has passed. I believe they asked her in cross-examination or direct, I can't remember which, that, okay, what could you change it after that? And I think she said, well, we try to do this to get the report out and finished by 90 days. That's our goal. It's not a rule. It's not a requirement, but we try to do it. But I think at that time, it's pretty much locked. I suppose there could be an amendment if some new information or evidence came in. But typically, they're pretty much done with what they want to say by then. Interesting. Texas Two Puds is asking, is there a reason the Commonwealth is not simply referred to as the state or the prosecution? I think you can refer to them as the prosecution, and it is a state. But Massachusetts is one of the states of the Union that's actually formed as a Commonwealth. And so typically would be called the Commonwealth. And that's just the way it's referred to in that particular state. All right. Mama Gigi asking about, what about the fact that every piece of evidence was introduced without Proctor up until the redirect on Buchanan, and then the defense opened the door and the Commonwealth got the Proctor taillight in. So I think it is definitely the case, and that's why I'm saying in this particular case, I do not think Trooper Proctor ends the case for the Commonwealth. Is it being used by the defense very effectively? Absolutely. It really is. It's really making an impact. But I don't think it ends things. There are physical pieces of evidence that Trooper Proctor found, and there are physical pieces of evidence that other people found. And those physical pieces of evidence are the most important links for the Commonwealth. And that's why I don't think that the defense can just end the case by saying Trooper Proctor, super bad job, really bad guy. I don't think that ends it. I think there's still going to be questions, and the jury is going to have to make those determinations. The jury is going to have to make those decisions. So the Commonwealth may not want to talk about Michael Proctor, but the defense is not going to let the jury forget him. I think they can come back. I think the Commonwealth absolutely can still win the case, but this has been painful for them. I think it's been something that has definitely hurt. We have a super special new outro tonight. As I mentioned, we are really close to 200,000 subscribers. We hope you will join us. We're about 2,000 away, I think. So please join us. But our mod Marlon has given us a brand new outro, which I think you will get a kick out of as we hopefully move forward to 200,000.